Ladies and gentlemen, I welcome all to my channel, and I'm Razak Ali, an advocate practicing in Chennai. We are sharing some of the important legal concepts, rules and regulations of law, which will be helpful to the people for their day-to-day life. Today we are going to discuss the topic power of attorney. What is meant by power of attorney? Why we should know about the power of attorney? What are the types? Registration is required or not? Validity of the power of attorney? Revocation? And what are the safety measures and the procedure to be followed in executing the power of attorney are all discussed in this video in detail. So this video will be a lengthy video to cover all the aspects of the power of attorney. Now let us see why should we know about the power of attorney. Most of the properties, whether it is either it's a flat or a plot of land, house site, most of them were sold and transferred by an agent in pursuance of the power of attorney. The owner of the property or the land will be somewhere else, and some other person, probably a real estate developer, a builder, will come and execute the power of attorney, execute the sale deed, and he will negotiate the price for the land and the property, and he will collect the sale consideration and other amount from us, and we are also giving the amount, paying the price and getting the sale deed registered without seeing the proper owner of the property. In such circumstances, suppose there is the power of attorney is not valid, or whether the power of attorney is has some sort of deficiency, or so it lacks some of the legal requirements, or suppose it's the original owner is not the power given by the person is not the real owner, then at the later stage you will face a lot of difficulties. You will not get the perfect title over the property because of the invalidity of the power of attorney. So in such circumstances, we will be in trouble. We may lose the property and we will not get the proper title over the property, and the original owner may come and claim the property and get back the property. So we will be in trouble. So in order to avoid all those things, we should know what is in the power of attorney, what are the safety measures in it, and how it is to be registered, what are the requirements to be fulfilled, and what are the things we have to check up when we are purchasing the property through agent, are all discussed, are all the important things. So I wanted to cover all those things in this video. Now what is meant by power of attorney? So power of attorney is a document wherein one person authorizes another person to do certain acts on behalf of the principal. So the person giving the power is called principal. The person authorized or empowered to act on behalf of the principal is called agent. So it is nothing but an authorization. So power of attorney is nothing but an authorization of a principal, authorization of one person, authorizing another person to do acts or to do some things on behalf of the principal. This is the power of attorney. So there are two types of power of attorney. The first one is called general power of attorney, and the second one is called special power of attorney. So when there is on the power, when there are several acts are involved, when a person gives power to do various acts, more than one acts, it is called general power of attorney. Suppose the man gives only one specific power and he gives only a power to do one particular one act, then that type of power of attorney is called special power of attorney. Normally, the power of attorney is given for the maintenance of the property. Sometimes it's also given for the sale of the property and for doing all sale formalities. Sometimes the power of attorney is given by the son or relatives to another relative to maintain the property, to collect the rent, to pay the property tax and other things, and also to file some cases on behalf of the owner. So when the power of attorney is given by a person to outside the family members for the sale of the property, then in that case the registration charges will be something more. Suppose the power of attorney is given by a father to his son, or a son to father, or power is given by a person to his own family members, then the registration charges and the stamp duty is a nominal amount. It will be around 1,000 rupees, it seems. In case when the power of attorney is given outside it, the stamp duty will be around, registration charges will be around 10,000. So somewhat high, 10 times higher than the rate applicable to the family members. So whether the registration is compulsory or not, if you ask this question, as far as the power of attorney is concerned, registration is not compulsory, but whenever the property is involved and when we have to sell the property or when we have to make some sort of transfer, either for a loan or mortgage or for any other things, in such cases the registration is required, because the registrar will accept only those power of attorney which is registered through a instrument. So for all other cases, supposing your son is residing in Singapore and he wanted to file a case in Chennai, and if he wanted to give authority, power of attorney to his father, empowering him to attend the court cases on his behalf, in those cases the registration through a registrar office is not necessary. A power of attorney by attestation by a notary public is itself is sufficient. So when the power of attorney, when the power of attorney is a general power of attorney, 100 rupees stamp paper is to be 100 rupees stamp duty is required, so it is to be typed in 100 rupees stamp paper. For a specific power of attorney, that is when only party to do one act, specific power of attorney, special power of attorney is made, and for that special power of attorney, the stamp duty is rupees 20 only. Now, we have also seen the registration and purposes, and also registration is not a compulsory. Only registration is optional for all power of attorney, but for the power given for the sale of the property, the registration is compulsory. Now let us see what is the validity period of the power of attorney. Supposing a power is given by one person to another, what is the validity? But how long it will be valid? Suppose the validity period is two types. As long as the power, the principal, the person who gives the power lives, the power of attorney is valid. Once he dies, the power of attorney is also dies with the person. So the power of attorney will dies with the persons. Second thing is, second type of limitation is, if the power given by one person is revoked or cancelled, in that case also the power of attorney comes to an end. So supposing A gives a power to B to sell the property, suppose and there is a dispute between A and B, and A cancels the power of attorney or A revokes the power of attorney, then automatically B will not get any power and any authority to make any sale deed or any transfer on behalf of the principal, because the power of attorney is cancelled or revoked. Sometimes you can see in the deed it will be mentioned that it is an irrevocable power of attorney. In law, there is no such irrevocable power of attorney is permissible. Even if it is mentioned that it is an irrevocable power of attorney, it can be revoked. It can be cancelled by the person who gives the power, Okay. In several circumstances, the people mistakenly understood that once the power is given, it is the person who got the power, the agent get absolute right over the property. It is not so. So the validity or the enforceability of the power of attorney is at the mercy of the giver, principal. So the principal may at any time, at his sweet will, can cancel or revoke the power of attorney at any time. So whenever we are going to purchase a property through an agent, we should check two things. Number one, whether the principal is alive on the date of power of attorney. Number two, whether the principal has not cancelled the power of attorney till the date of registration. In one case, what happened now, the agent came to register office and executed a sale deed at the register office at around 2 o'clock. At a later stage, it came to the knowledge that the person who gave the power died on the same day in the morning 9 o'clock. Subsequently, his legal guest challenged the transaction, saying that this transfer made by the agent is not valid because at about 2 o'clock their father was not alive. So legally speaking, the power of attorney dies with the person, and so whenever we go to register office or whenever we wanted to purchase a property through a power of attorney, we should check whether the person who gave the power of attorney is alive or not. Nowadays, the register office also asks the agent to give a life certificate from a government doctor certifying that the person who gave the power was alive on the date of registration, or at least within one week before the date of registration. So the registration, this procedure was initiated, and it was made as a rule in the register office to check whether the person who gave the power is alive. Second thing is, suppose he cancels the power of attorney, automatically it will be reflected in the concerned register office. So whenever we wanted to go to purchase a property through a power of attorney, before making major payments or before going for registration of the sale deed, we should check whether the power given or the power of attorney is valid and the power of attorney was not revoked till the date of registration. So we have to check it with the concerned register office that the power given by the principal is still alive. So the power can be revoked at any time, cancelled at any time, as per the sweet will of the principal at any time. So there is a risk whenever we wanted to make any payment or any deal with the agent, and so we have to check these two things before making the major payments on before going for a registration of a sale deed.